Welcome to ABIEdu Academy. In this lesson, we will break down negligence, one of the most important areas of tort law. To succeed in a negligence claim, a plaintiff must prove four essential elements: a duty of care, a breach of the standard of care, causation, and damage. If any one of these is missing, the claim fails. Let us look at each in turn with examples. The first element is that a duty of care must exist. The defendant must owe the plaintiff a legal duty to take reasonable care. A duty arises where harm to the plaintiff was reasonably foreseeable, and there is a relationship of sufficient proximity between the parties. This is often called the neighbor principle, from the famous case of Donoghue versus Stevenson. We must take reasonable care to avoid acts we can reasonably foresee would injure our neighbors, the people closely and directly affected by our actions. For example, a driver owes a duty of care to other road users and pedestrians. A doctor owes a duty of care to their patient. And a manufacturer owes a duty of care to the consumers who use its products. Without a duty, there can be no negligence. The second element is a breach of the standard of care. Once a duty exists, we ask whether the defendant met the required standard. The law uses an objective test, the standard of the reasonable person acting in the same circumstances. Did the defendant do what a reasonable, prudent person would have done? If they fell short, they have breached the standard. For example, a driver who is texting instead of watching the road has breached the standard of care because a reasonable driver would keep their attention on the road. A professional, such as a doctor or an accountant, is held to the standard of a reasonable member of that profession. Courts weigh factors like the likelihood of harm, how serious the potential harm is, and the cost of taking precautions. The third element is causation. The plaintiff must show that the breach actually caused their harm. Causation has two parts. The first is factual causation, tested by the but-for test. But for the defendant's breach, would the harm have occurred? If the harm would have happened anyway, the breach did not cause it. The second is legal causation, or remoteness. The harm must not be too remote. It must be a reasonably foreseeable consequence of the breach. For example, but for a driver running a red light, the pedestrian would not have been struck, so factual causation is met. And being hit by a car is a foreseeable result of running a red light, so it is not too remote. The fourth element is damage. The plaintiff must have suffered actual, legally recognized harm or loss, such as physical injury, damage to property, or financial loss. This is a key point. Unlike some intentional torts, negligence is not actionable without damage. No harm means no claim, even if the defendant was careless. For example, if the pedestrian who was struck suffers a broken leg, medical expenses, and lost income, that is recoverable damage. But if a driver runs a red light and no one is harmed, there is no negligence claim because the damage element is missing. To bring it together, to win a negligence case, the plaintiff must prove, on the balance of probabilities, that the defendant owed a duty of care, breached the standard of care, that the breach caused the harm, and that real damage resulted. Remove any single element, and the claim cannot succeed. These four elements are the backbone of negligence law. Thank you for learning with ABIEdu Academy. If you found this lesson helpful, subscribe for more learning, and we will see you in the next one.